one of those overlook into the house, and their use of clearly designated winter gardens as domestic spaces, I think that has made this overlooking far worse than it would have been had they been used as winter gardens, which are essentially balconies. But yes.
Okay, thank you.
Thank you.
Hi, my name's Lilia, and in my essay, I answered the question of why I believed Fern and Tate added clarity to the law of nuisance. I'll address two main points about what a common and ordinary use actually is, and the role that human rights did or didn't play in the case, and how language connected the two together. So on February the 1st, the Supreme Court held that the Tate Modern was liable to the claimants under the law of nuisance, as Tate Modern's viewing platform was ruled as a legal nuisance. Throughout my essay, I explained why the case of Fern and Tate, and more specifically the Supreme Court, helped to provide clarity to the law of nuisance by defining what actually constitutes as a legal nuisance. And whilst I still maintain this stance, I believe the case also helped to widen the scope for the possible claims that can arise in a nuisance case, more specifically human rights claims. So firstly, the Supreme Court helps outline the distinction between the overlooking of an adjacent property and a visual intrusion, arguing that the viewing gallery extended beyond incidental looking and was a visual intrusion. And whilst it could be argued that this distinction added further confusion to the law of nuisance, as the Court of Appeal found a problem and found it, quote, difficult to envisage any clear legal guidance as to where the line would be drawn between what is legal and what is not. I believe it is better argued that the distinction helped to prevent erasing the line between legal and not legal altogether. Additionally, whilst I would argue that the case provided clarity to the law of nuisance by presenting significant distinctions, it also tackled the foundational issues which can lead to confusion in law, namely language. In my essay, I alluded many times to the importance of language in law, and more specifically in the case of Fern and Tate, as the law of nuisance can be misconstrued through language. The High Court judge argued whether the viewing gallery was unreasonable or reasonable, whereas Lord Leggett outlined how instead we should consider if it was a common and ordinary use of land. This highlighted the false dichotomy that was created by the High Court by considering if something was unreasonable or reasonable, whereas considering the viewing gallery should be considered if it was a common and ordinary use, and also highlights the danger of semantics in law. I believe this helped to identify a common and ordinary use as the crux of the case, as well as outlining how language itself can provide clarity in law. Additionally, the Supreme Court's ruling illustrates a developmental shift in law of nuisance, as in the case of Hunter and Canary Wharf 1995, a legal nuisance was only considered to have occurred when there is an interest in the land affected, whereas in 2023 in Fern and Tate, the definition of an illegal nuisance is focused back to the nuisance itself, providing a more focused and straightforward approach to defining what actually constitutes a legal nuisance. The case also explored what actually constitutes as a common and ordinary use. Many courts have previously incorporated words such as substantial in order to stress the level to which there has been an interference on the claimant's land. This was explored by Lord Leggett in reference to the case of Southwark London Borough Council and Tanner in 2001, where adjoining apartments lack sound insulation, but activities such as cooking and watching the TV, although very audible, were no more than simply neighbours exercising a common and ordinary use of their land. Through comparison, it can be most definitely concluded that a viewing gallery was in no way a common and ordinary use, and also further adding that inviting several hundreds of thousands of visitors a year to look out the view of your building cannot be any stretch of the imagination regarded as a common and ordinary use of land. This quantifier of a nuisance also provided a clearer understanding of the level of interference. So the Supreme Court's ruling of there being a substantial interference is important in expressing the level of interference, while setting a precedent for latter nuisance cases, and in this case was a significant one. However, what interested me the most in this case was the topic of human rights. The topic was raised in this case on the ground that there was a violation of convention rights from the European Convention for the Protection of Human Rights. More specifically, Article 8, the right to respect for private and family life. The appellants claim that the viewing platform and the number of visitors looking into their apartments violated Article 8, and also that the Tate Modern as an authority was in breach of Section 6 of the Human Rights Act of 1998. The claim was ignored by the High Court and Supreme Court, and it was ruled that there was no need or justification for involving human rights law when common law already has developed tried and tested principles to determine when liability arises. And it was argued that the claims were relevant to the case. And although Article 8 itself didn't play a significant role in the outcome of the case, it still became a noteworthy topic through its significance, through its discussion, but it was dismissed by all courts on the ground of relevancy. However, I would argue that human rights may be necessary if these tried and tested principles fail to determine liability. Then there could be a necessity for human rights claims. It could also be argued that human rights shouldn't just be a way to reinforce a claim, like the appellants used in this case, but instead could play a more significant role through proportionality. This could be a key way in determining if human rights are in fact relevant, or better described as appropriate or necessary to nuisance cases. As a result, this could be a more interwoven way to consider human rights alongside nuisance and would tackle the issue of relevancy head-on. Overall, as highlighted by the case and Lord Legate's distinction and the previous points I've mentioned, language and linguistics plays a significant role in law, and especially the law of nuisance. However, what would happen if this was questioned further to invoke human rights claims into the law of nuisance? It could be argued that human rights should play a more prominent role in nuisance on the grounds of language. That in fact there is an intrinsic link between property and the personal in nuisance cases. For example, how can one even approach nuisance cases where, for example, Smith cannot sit in their garden without the sound of planes, and Jones can no longer open their windows without smelling sewage, without even considering the personal aspect of there that is immediately applied through even a singular word, as it isn't just referred to as the garden that Smith happens to be in, or Jones's windows. It's their garden. Therefore, language already imposes significant weight on the personal aspect of nuisance. And for this reason, does the law of nuisance require the role of human rights? Thank you.
Thank you.
So I just got a question about the common and ordinary use test. Do you say that that's an exacting enough standard? I mean, obviously it still will leave room for a lot of interpretation, and some might say that actually having a viewing gallery is an ordinary use of an art gallery such as the Tate, which reaches many, many floors and could provide a great view of London, albeit also into these people's homes. But is it your argument that having some flexibility in the law is a good thing, or could it lead to uncertainty?
I think that it definitely could be argued that it might lead to uncertainty, but I think that it's better to argue that providing more flexibility within the law to debate it and to be able to discuss it is better than just providing, if it's just questioning if it's reasonable or unreasonable, as it sort of limits it to if it's reasonable or unreasonable. And then I think it further complicates it in that sense, because then you have to question, well, what's reasonable and what's unreasonable? Whereas I think by giving the guidelines of a common and ordinary use, that's a stricter and more simpler definition to adhere to or to question.
So how do you apply that, for instance, to a football stadium? Is Arsenal's Emirates Stadium a common and ordinary use of land?
Well, I think you'd have to consider the other things nearby. So if there were other buildings where lots of people spent time in, that was populated quite a lot, whereas if it was in the middle of nowhere and it was quite quiet and there were already habitats that would be disturbed, then that might not be a common and ordinary use of land. Whereas if it was in the vicinity of other buildings that were used quite frequently and used for other events, then it might be a common and ordinary use of land relating to other things nearby.
Intrigued by your emphasis on language and how the use of language might determine the outcome of the case, as I understand it. The judge at first instance in the Court of Appeal used the term overlooking a lot, question of whether it can be a nuisance to overlook another property. Lord Legate preferred a different term, visual intrusion. Which term would you prefer, and why when analysing this case?
I think visual intrusion, it's more linked to how it feels to the appellant. So overlooking implies that someone just happened to peer in or just happened to watch, whereas visual intrusion stresses the level of intrusion and the level of interference within the appellant's property. I think it stresses and weighs in more to the personal aspect that is felt through a nuisance case.
Thank you.
Okay, thank you.
Okay.
Good afternoon, I'm Hayley, and I'm going to be talking to you about why the Supreme Court decision of Fern and Tate was correct. And to do this, I'm going to take you through the legal criteria needed for a claim of nuisance to be successful. So firstly, it must be a use of land that wrongfully interferes with the ordinary use and enjoyment of neighbouring land. You could argue, since there's no physical encroachment, the appellant's lives are not necessarily interfered with. But according to Hunt and Canary Wharf judgment, there are 3 types of nuisance, one of which is the interference of the quiet enjoyment of a neighbour's land. Put yourself in the situation of the appellants. Would you be able to quietly enjoy your apartment while being watched through your windows by hundreds of people? You would definitely feel uncomfortable, as would anyone. So the enjoyment of the apartment is definitely interfered with. You may say, well, that doesn't prove enough. The criteria says the use of land also must be proven. The case of Williams and Network Rail Infrastructure shows the law can also allow diminished amenity value as a basis for nuisance. And this aspect definitely applies to this case, as the viewing platform would negatively impact the current homeowner's ability to sell their property because of the overlooking of the balcony. Although the appellants chose to buy an apartment with glass walls in London, a busy city where overlooking is quite common, there's a fundamental principle that coming to the nuisance is not a defence, as confirmed by Coventry and Lawrence. Therefore, the appellants cannot necessarily be blamed for not taking preventative measures or for the nuisance occurring in the first place. The second criteria is the interference must be substantial to an ordinary person. The descriptions of people being filmed in their own homes and others even using binoculars to look into their apartments shows a clear intention to invade someone's privacy. This consistent invasion clearly did have a substantial effect on the appellants, who described it like being in a zoo and filed a claim for nuisance after numerous complaints to the Tate. The Protection from Harassment Act 1997 and Bernstein and Skyviews both protect the individual's right to privacy and are violated by the actions of the people on the balcony. Also, Article 8 of the Human Rights Act is also violated here. Although the article originally binds authorities only, the Act also says it must be considered in every case, and it does apply here, as the Tate are implicit. They have a responsibility to take harsher action if there are crimes being committed on their property and the measures they have already taken have not worked. The Court of Human Rights have never ruled mere overlooking as an Article 8 breach. However, this case is not just about overlooking. This argument discounts the involvement of photos being released on social media, which elevate the nature of this case. The third criteria is whether the use of land is uncommon or unordinary. How can we decide what is uncommon? Something to consider is the character of the locality. So the platform could be seen as ordinary due to the tourism status of London. However, there's an important distinction to make between reasonable and ordinary. While the purpose of the platform may be reasonable in order to bring in money and publicity for the Tate, that does not make the platform ordinary. The unique selling point of the platform is that it's the only 360-degree balcony in the centre of London, and this proves the use of land is not ordinary, as the special nature of the platform is what the Tate used to in fact promote it. There's also a public interest element that should be considered, as the Tate is a national art gallery providing public access to this view. The Supreme Court did say the decisions from the previous courts were probably influenced by the public nature of the Tate. But while account should be taken when an activity is of public benefit, That does not go towards the issue of liability for nuisance, but rather what remedy is appropriate in response, for example, an injunction or damages. Outside of this criteria, the legacy of the case must also be decided due to the President's Supreme Court decision set. The judgment would provide more guidance into what a nuisance actually constitutes, which would be important as there's no a priori limit to what a nuisance can be. Also, it would arguably protect the rights of landowners, as there would be changes to risk assessments. However, this case could be seen in a different light also. Some may think this judgment would lead to overlooking being consistently sued. However, this does not take into account the fact that there are many criteria for a disturbance to be qualified as a nuisance. Lord Legate himself, who provided the leading judgment for the Supreme Court, claims that the specific circumstances for nuisance to be actionable are likely to be rare. But the potential for these claims has increased due to advances in technology, which allow for filming and photography, and these can cause a more major interference than simply looking into someone's apartment. Therefore, it could be seen that the law around nuisance is simply changing in line with social developments, and this will help protect others and keep the law more up to date. Overall, what have we learnt? Does this case fit the criteria for being the correct decision? The Blavatnik balcony caused a significant interference with the loss of amenity value of the apartments and the reduced ability of the applicants to enjoy their own land. There were half-hearted measures taken by the Tate in response to the clear and consistent violations of privacy in tort law and human rights law. The interference is not justifiable as the land isn't being used for an ordinary purpose. Finally, the legacy of the decision will give more guidance to future decisions and will allow for a greater balance of interests between landowners, which is ultimately what the concept of nuisance aims to do. There's no reason for the viewing platform to not be seen for what it is, nuisance in action. Thank you.
Thank you. You referred to the half-hearted measures taken by the Tate to prevent intrusion into the flat owners' lives. Are there any measures which you think the Tate could have taken to avoid being liable in this case, short of actually closing the gallery?
I think they could have reduced the scope of the gallery. So the fact it is 360 degrees all the way around, I understand that is part of the selling point, but also when part of the gallery is also looking into people's homes, I feel like that would be reason enough to close maybe that part down, because it's not really offering what they said it would, which is the view of London is looking into people's homes and causing an interference.
So I've got a question. You said that the Supreme Court thought that allowing visual intrusion claims would only involve liability being found in rare cases. So my question is, do you agree with that? And if so, what type of cases would you also find defendants liable for visual intrusion?
I think one of the main things for me was the use of land and whether it's ordinary or not. So in the context of the locality, you'd have to see if, firstly, if it is an ordinary use, and also if there is some efforts by both sides to sort of, in a way, make sure that they're not intruding on each other's land. And I think that the Tate, they do have a larger responsibility because they are a public sort of authority. So they've allowed people to go on the balcony. And they do have to take an element of responsibility for the actions of the people if they have not set clear guidelines as to what is allowed and not allowed.
I've just got one question. So why should the public interest not play a greater role in the test for nuisance to align it with Article 8, especially considering the possible impact on, for example, the interest of all the thousands of members of the public who enjoyed being able to access the balcony at the Tate previously? Wouldn't it make it kind of a fair and more kind of commercial test, because businesses that are seeking to innovate and use very kind of new types of entertainment for the public would feel more able to do so without a risk of nuisance claims.
Yeah, I can understand that perspective. However, I think there needs to be a balance between the commercial aspect and the sort of individual aspect. So obviously the apartments are just like sort of private, it's just their homes. And I think that ultimately the commercial aspect can't outweigh this personal aspect. And because of the fact that, I mean, if it was any of our homes, I feel like we would feel the same way the applicants felt. And the commercial, the Tate really, they do have other options. And I think that they did have like the rest of the balcony, and they are able to still go ahead and innovate and go forward with new ideas.
Thank you.
Thank you.
So I'm Eve, and I've written my essay in response to the statement that the Supreme Court decision of Fern and Tate provides clarity to the law of nuisance. So this case was very controversial, as it doesn't always follow nuisance case law that came before it, and this can be interpreted as a lack of clarity. But I would say that the decision does provide clarity to the law of nuisance, and the way in which what I've really been thinking about since my essay is kind of how a case can provide clarity and what takes away from clarity. And I think the way that this case provides this clarity is as it furthers previous precedent and adds on to that, but it also establishes its own and breaks away when necessary. So that is, and then that's in addition to kind of the fact that I've acknowledged that there are reasons that it could be interpreted as a lack of clarity, but I see that as a misinterpretation. So the only factor that for me, only constitutes a lack of clarity is kind of where the burden of nuisance is put. So first of all, there's a lack of continuity between all three courts. For example, the Court of First Instance focusing on preventative measures, the Court of Appeal focusing on the liability of planning authorities, and the Supreme Court focusing on the burden being on the Tate Modern. I mean, as Kate Andrews highlights, this lack of insight with planning would be intolerable, and I would agree that it should be more of a focus, kind of preventative measures, and that could be something that you would say takes away from the clarity, because there's the role of the planning authorities isn't as emphasised as much in the Supreme Court's decision. But overall, in most of the other factors considered in the case, I would say that it does provide clarity. And the first way is through following precedent. And one of the precedents it follows is the common and ordinary use of land, which was this terminology was established in Bamford and Tunley in 1862. And whereas Lord Kitchen kind of went against this, focusing on a reasonableness between neighbours, Lord Legate reaffirmed that common and ordinary was how this platform should be looked at. And I think it's important when you look at the emphasis on how the land was being used. For example, a viewing platform, the purpose is to look out onto what you can see, which is different to, say, a cafe or any other way that people would be enjoying the land. So overall, a viewing platform cannot be considered common or ordinary use of land, and it follows Bamford and Tunley. And another way is that the issue of public interest. So whilst Emily's does make the point that there is a political aspect to the case, in that kind of with the accessibility of the view of the Thames, because it should not be that the Tate Modern is an accessible way for people to be able to experience this view, whereas not everybody can have a floor-to-ceiling windows apartment. And I do think that's very important, but in terms of providing clarity to the law of nuisance, the two main cases that it follows are Coventry and Lawrence, where kind of public interest was a factor involved in determining liability but not in deciding the remedy. And then in Dennis and Ministry of Defence, it was kind of set out that you can't deny remedy based on public interest. And another way that Fern and Tate follows case law is the idea of coming to the nuisance that was set out in Coventry and Lawrence. And I think it's quite easy to ask the question of why you would buy a house with floor-to-ceiling windows if you would then decide to make a claim against people looking into your apartment, especially when you are living in London. But Fern and Tate does follow this, as it does not matter if they were aware or whether they should have been aware, and this is very clear as it's a very set continuation of case law. But the most interesting part of the case, I think, is how it kind of establishes its own precedent and kind of breaks away where deemed necessary. So the first way it does this is in kind of the idea of what constitutes a nuisance. So there is obviously the floodgate argument of if overlooking can constitute a nuisance, as the Court of Appeal put it. It was kind of worded as mere overlooking, and kind of the idea that it could be warped to the blame being put on people based on what they can see, and it raises the question of if there's a limit. And there's also, in response to the Tapling and Jones case, where visual nuisance was kind of disregarded, Fern and Tate seems quite revolutionary in this way. But I think it does provide clarity because, the agreement of all 5 Supreme Court judges that overlooking can be a nuisance definitely says something about that. But I think the most interesting bit is that it kind of focuses on making decisions on a case-to-case basis and kind of questions the idea of the decision of a case being to set precedent. It's not saying, I don't think Fern and Tate should say that every time overlooking is always a nuisance in the way that other things can be, but I think with the aim of tort law being equity and fairness, it just kind of shows that the focus should be on the equity and fairness between both parties rather than necessarily this terminology that is obviously useful in making decisions but should not be the be-all and end-all factor. And finally, the idea of privacy and human rights. So obviously these, including tort law, these are all different aspects of the law, and I think Fern and Tate quite interestingly deals with how different aspects of the law fit together. So in McKennitt and Ash, it was established that the right to privacy contained in Article 8 of the Human Rights Act is more important than the right to freedom of expression in Article 10. But the Supreme Court declared that Article 8 does not apply. So this is quite concrete precedent. This is quite a fixed example. And I think the way that it is kind of making its own statements kind of shows how it's adding clarity by establishing its own precedent for other cases to go off in the future. So ultimately, I think the case was expectedly controversial, but I think this is really important because controversial cases are important so that case law can adapt and change. Like, for example, some of the cases that I've mentioned, such as Tapling and Jones, it was in 1865, which is kind of, I don't feel that we should be bound to decisions made by people living in a completely different society. For example, back when that decision was made, floor-to-ceiling windows would not have been such an issue as they are today. So I think it's important that cases do not feel that they are completely stuck to what has gone before them and feel that they have the freedom within the law of nuisance to do what is best and do what is most fair to get the right outcome. And that's why I think that Fern and Tate provides clarity to the law of nuisance.
I've just got a question about the privacy angle.
Yeah.
So in privacy law, neither Article 8 nor Article 10 trump the other.
Yeah.
Is it your view that Article 8 in a nuisance type claim should trump any other right? And how could that work in practice?
Yeah, well, I suppose it kind of links to the idea of public interest. I suppose it's the idea that it is their right to privacy and that it is the right to their land and the ownership of their land, meaning that it is their privacy. Whereas, I suppose, in terms of the Tate, it's not. They're the ones that are infringing this rather than expressing, and I think the focus should be more on the people who are being intruded on.
Okay, so your argument is that Fern has brought clarity to the law. At the heart of the reasoning in Fern is this idea of the common and ordinary use of land.
Yeah.
You're using land for common and ordinary uses. What you do can't be a nuisance. So I'd like to suggest to you that that's in fact a very imprecise, unclear test. And isn't that demonstrated by this example? Suppose you have a next door neighbour who gives singing and piano lessons for 2 hours or 3 hours each evening, and that disturbs you. I mean, isn't it pretty unclear whether that's a common and ordinary use of land?
I think it can be unclear, but I think all the wording in this can tend to be. I mean, even what a nuisance constitutes can be considered unclear. But I think specifically within Fern and Tate, I think the idea of common and ordinary is quite easily decided due to the function of the building being a viewing platform, which is not. And I suppose it would be more difficult to decide in cases such as when issues between neighbours. But I think
So what about my example of the next door neighbour that has singing and piano lessons for 2 hours each evening? Is that a common and ordinary use of land?
I suppose it's really the interests of the two. If it's the interests of the two kind of parties in the case, if that's that person's, you've kind of got to weigh up the fact that that could be that other person's way of making money, that's that other person's way of, that's their job, weighed against the person living there. But I would say that it would almost be better to use, kind of as Lord Kitchen said, the idea of reasonableness between neighbours. Is it that the singing lessons have to be done at that hour? Is it that they have to be done? Is it that it could be decided that they could be done slightly quieter? Whereas that aspect isn't really prevalent in Fern and Tate.
Yes, so sort of picking up on that slightly. You draw attention to the clarity which you say comes through the common and ordinary user test.
Yeah.
Is there a danger in your view that clarity then leads to a lack of innovation in the law? You also drew attention to some technological innovations, social media, and one of the things Lord Sales said in the dissenting judgment, which you referred to, that the history of the development of the country's urban areas has been one of innovation. So what's your view about which side of the line the judgment of the majority came in favour of clarity or innovation?
Well, I would say that common and ordinary, whilst it can change over time, it has to be kind of responded to at the time we're looking at. And I would say at the time of Fern v Tate in 2023, it is still not a common and ordinary use of land. It definitely wouldn't have been a common and ordinary use of land, but I think the bit is that it still is not. So obviously, it's innovation is important and it should be enabled, but I think the issue isn't just that the land is common and ordinary, the land is not a common and ordinary use. The issue is that this use that is not common or ordinary infringes on other people. I think that is the more important aspect, and I'd say that in this case it kind of just assists the argument.
Thank you.
Thank you.
Okay, thank you all. So we're going to deliberate now, please.
I guess so.
Yeah. Yeah. Okay, I mean, first thing, we thought, so we were impressed, Jake and I were impressed when we participated in the online session. And we were so impressed today, all of us, and we went outside. And the first thing we kind of all said was how fantastic everyone was. So well done, everyone. And so we thought we'd start by giving you feedback individually, and then tell you who we thought has won. So Kirthana first. I thought the written paper was brilliant, really clear, very well written, shows a really good understanding of the law, and I thought you presented very well. It was very clear, you had a good structure, starting off by saying there's two things to deal with, and I thought you answered the questions well, you're confident. Overall, I thought excellent.
Lilia, yes, I also enjoyed your paper very much, particularly the way in which you drew out the distinction between visual intrusion and overlooking, which seems to be one of the real differences between the Court of Appeal and the Supreme Court. And then I thought you developed that in your oral presentation very well. You went beyond the distinction you drew there and the emphasis on language and semantics. So I find that very interesting, because I think that's a real, whether you look at it as simply overlooking, or whether you look at it as visual intrusion is the heart of the case in many ways. I thought your presentation was very good, perhaps a little bit nervous for the first sort of 10 seconds or so, but then you relaxed into it and you were sort of standing up straight, speaking clearly. Careful not to go too fast, but I say when you relaxed into it, I thought that was good. And I enjoy, just back to the content, the emphasis on proportionality as well, which is an important concept throughout human rights, and one can see the difference here between the Court of Appeal and the judge. Well, the judge in particular was talking about proportionality, but the Supreme Court was taking a more sort of strict view of things. So excellent, thank you.
So Eve, I liked your presentation style. I thought you were really confident, a lot more confident than I would be if I was stood there doing this exercise. And I also liked that you weren't reading, that your arguments felt quite fluid and natural, and also the way that you structured your submissions. It was a good structure, and you followed that structure throughout. As to your paper, I thought it was good that you considered the kind of wider implications of the judgment. Obviously, it's a Supreme Court judgment, but you kind of at times questioned how wide the implications would be. And also, as a privacy lawyer, I liked that you developed your argument about Article 8 in oral submissions, which you touched upon in your written submissions as well.
Hey, excellent. Very well presented, very clear, calm presentation. And the thing that struck me throughout your presentation, you kept bringing things back to the facts. I think law can, you're discussing the sort of first principles of law, it can all seem and be quite sort of abstract. But over and over again, you kept bringing it back to facts of the case. You said, put yourself in the position of the claimants. You talked about what it would be like to be looked at with binoculars. You talked about the taste of public authority, rather than sort of letting them off in some way. You said, isn't it more incumbent on them as a public authority to do the right thing in this case? So I thought very well presented, dealt with the questions very well, but I particularly liked, and I think we all did, the way you kept bringing what can seem quite abstract arguments back to concrete facts. So that's the individual feedback. And in terms of the winner, there was a debate. We found it really difficult. And as I said at the start, we all genuinely thought the quality of your presentations today were really excellent. But just about Kearthana, you edged it.
Congratulations, all of you.
Thank you so much, Jacob, Tom, and Lee for judging this evening. We do have some prizes for all of our finalists. And I don't know if that's just some photos as well at this point.
Yep.
Oh, yes. Yes.
They're Supreme Court books. Architectural history and academic detail books.
Very impressive, very heavy coverage over books about the Supreme Court history, art, and architecture. If you have a chance to have a tour of this building, you should. Particularly the carpets and the logo. The carpet was designed by Lady Hale?
No.
It's Lady Hill and Sir Peter Blake who designed the Beatles album, of course.
Right.
We've actually having a tour at the end of that loop, so so I don't know if you want to all come up to the front and take some photos.
So shall we stand at the front?
Yes, that's important.
Get one of our cameras to take photos. Because one of our cameras and we can share. Yes.
So we smooth side. Yeah. Up to a little bit. Did you want to sit down and take some photos? Yeah.
It's a very different experience sitting behind here. All three of us have spent several days sitting on those benches, and it's terrifying.
Good, thank you.
Thank you.
Thank you.
Head on a tour?
Yeah, we're more than welcome to stay till 7 o'clock. So I'm more than happy to give sort of like a 20-minute, 25-minute tour to everyone as we sort of depart, if that's okay with everyone.